Good morning, everyone. Today is July 21st, 2022, and welcome to the New Possibilities Hour, part of the Will Work for Food project founded by Natalie Armstrong Motan in the spring of 2020. Every Thursday, Jean Lawler and I, along with Natalie and Sarah Agamiri, host another cutting-edge webinar of interest to mediators and arbitrators, lawyers, and really anybody who negotiates. And we're delighted to have a very special guest today. Before we get to our special guest, one of my favorite parts of the program every week, is when we announce the running total of how much our generous audiences have contributed to food banks around the world. Because there's no charge for these great webinars, we ask you to contribute to a food bank if you like what you see. And Jean, I know we've been tickling the $300,000 number for the last few weeks. Are we there?
Not quite, but I would say maybe today will be the day. $297,191.86 in donations to food banks, of which we have been advised. So, you know, it's more than that, and it's more than 3 million meals. Fantastic.
Well, that's tremendous. And I am confident that the audience today will make David Armstrong the answer to that pub trivia question, which will last for years. Who was the speaker who put the Will Work for Food project above the $300,000 mark? And now for a very special introduction of David Armstrong, we have Natalie Armstrong Motan. Natalie, please take it away.
Thanks so much, Jeff. I know that today is a little out of the ordinary, but I do want to give a little bit of background about a person who, though Armstrong is a common enough name, is not related to the astronaut Neil Armstrong, nor related to the cyclist Lance Armstrong, but he is related to me. So I am very honored, very pleased that I get to introduce you all to my father, David Armstrong. And so he has a long background, more than I do. I've been around for 2.5 decades. He's been around for almost 3 in the industry. And he is, an educator, an arbitrator, a mediator, a dispute review board panelist. He's done, I don't know how many thousands of construction industry cases. He's served as a neutral in more than 4,000 construction disputes around the world regarding project delays and change order requests, patent defects, latent defects, on and on the list goes, earthquake damage, structural, all kinds of things. And the talk that he's going to give us today is about dispute review boards. This is a talk that he has given to classes, audiences, municipalities, departments of transportation, state governments, federal justices, Supreme Court judges, all different kinds of audiences. And I'm really excited to have him talk to you today about dispute review boards. It is one of my all-time favorite resolution processes. So I will turn it over to my father, David T. Armstrong. Would you tell us a little bit about the food bank that you've chosen for us, please, Dad? And then the floor is yours.
Absolutely. Any donations to the Idaho Food Bank, and they have a website. You can go on and make your donations. And Idaho is no different than other communities. There are children that need food and families that need food. So if you could help out, that would be great. And I'm very anxious to talk to you about dispute review boards. As Natalie has said, I started in the ADR business in the early 80s. And started out arbitrating. I really liked arbitration. And then when Janet Reno, under the Clinton administration, introduced the ADR, or mediation in the federal courts, absolutely fell in love with that idea of letting people resolve their own disputes with the help of a mediator. That encouraged me to go to the university in Pepperdine and Malibu, Pepperdine. And one of my great professors was Jeff Kitchhaven, which is a part of the board of this Feed America program. So Jeff, thank you for all of your input and your encouragement to continue pursuing the ADR business. One of the things that I thought was really great, Janet Reno, when she wrote a lot of the documents for the Clinton administration, when she used the acronym ADR, it was not for alternative dispute resolution. She used it as appropriate dispute resolution. And that, to me, was kind of sent me into studying, is there even something better than mediation, something else? Because we all know that disputes start, it's kind of a three-phase process. Every dispute starts with an issue. And if possible, that a neutral could help groups or partnerships or whatever work at that issue stage, perhaps they could keep it from going to conflict, because conflict is the second step. So an issue comes up, that means that in the construction industry, perhaps the plans don't match what's in the specifications. It's noted at a monthly meeting or a weekly meeting between the owner and the contractor. And they say, well, you know, that's a pretty small issue. I think we can just resolve it now and put in a change order, whatever it takes, or change the spec to match the plan. If they don't resolve it at that stage, then it turns into a conflict. And that's where the owner and the project supervisor or contractor then would say, look, if I make this change, I'm gonna have to be compensated. Well, we're not so sure you deserve compensation. The next phase, it goes to a dispute. And that's where each side takes a position. And unfortunately, in the mediation business and in the arbitration business, that's where we come in typically, is once the dispute has been defined. And we help them resolve their own, or we make the decision for them. What's interesting about the dispute resolution process is that out of a panel, pre-selected panel, pre-qualified panel of people from the ADR industry, the two parties, each, anyway, the ones that I'm on, they select 5 choices each, and they see if any of those cross, because they're looking for at least 3 neutrals to serve on this particular project. Some of these projects are 3-5-year projects. Some of them are very, very complex projects that involve several owners, such as counties, cities, private property, resort property, highway district property. And funding sometimes is through the World Bank, sometimes through local banks, sometimes personal financing. So they're complex, typically complex projects that we use the DRB on. Once the parties can agree on, and the ones that I serve on, 3 neutrals, those neutrals select a chairman. And that chairman is the one that communicates to the owner and to the contractor. I'll just use the simple term contractor, provider. And he or she discusses only the process, but never an issue or anything in the progress of the project, just about process. This neutral body meets from the day one with the owner and the provider. And they sign an agreement that's a 3-party agreement before the project ever starts. And the 3 parties are the owner, the provider, and the board. And we have very specific terms of how the board is to resolve issues. That talks about their neutrality. The neutrality issues are the same as in mediation and arbitration. We don't participate individually with either the owner or the provider. We keep our distance, and we go to the monthly meetings or weekly meetings or quarterly meetings, whatever, and we sit quietly. We listen intently. And if an issue comes up, then perhaps we participate. Once their meeting is done, they'll always ask, do you see any issues? And we always turn the table on them and we say, do you have some issues? Do you know of issues? We noticed that you mentioned that on the plans, it's for the signage post, it specifies metal posts, but in the specs, it's wood posts. So can you work together and get that one resolved? Yes, we can. That's not an issue. We'll choose one or the other. So we do participate. So let's just go through the three initials, DRB. So let's start with B, the letter B, board. The board is a neutral body selected, like I said, from a collection of ADR providers. Then the contractor chooses 5 typically, and the owner chooses 5. They cross, they work it out until they can get 3. So, and the chairman then is selected by the board itself. They set up their very first meeting. Typically, these meetings are before the project even gets started. So we go to these meetings. We totally disclose any possible conflicts of interest, just like we do in mediation or in arbitration. And we listen intently for any issues and hopefully can address them. Now, as the same as in mediation and arbitration, anything that's discussed in these meetings with the provider and the owner, it's totally confidential. And we assure them that no information is ever leaked. So the only thing that's discoverable in these DRBs is our recommendations. So let's talk about that for just a moment. We do, different from arbitration, we do not give a definitive decision, binding or non-binding. We do not stand back and just coach people to come up with their own agreement. With our expertise in the industry, whether it's law, whether it's construction, whether it's engineering, whatever, naturalists, scientists, those types of individuals that sit on these boards, we write recommendations. The recommendation is discoverable in a court of law if they don't get it resolved and they do go to court. We have what's called an informal review, and that's where we can verbally give a recommendation. Maybe we only take a 10-minute break. We make just a verbal recommendation. We can write a very simple informal recommendation, or we can do a formal review. Informal reviews are very similar to an arbitration where the complainant has the opportunity to present their side and then the respondent responds. You do rebuttals and then you open it up to general conversation. And we try to keep it on a very friendly environment. And our focus, the DRB panel's focus, is purely on the project. We don't represent the contractor or the provider of services, nor do we cater to the owner. We only look at the project. So that's basically what the DRB board does. Let's go to the R of the DRB. Like I said, the resolution is a recommendation. And sometimes in some of the boards that I'm on, these recommendations can be 20, 30, 40 pages, maybe even maybe the largest one that we did was 70 pages, where we we do have the opportunity to hire outside experts and bring them in and give us a neutral, say, sampling of asphalt or concrete or testing the structural steel to see if it met the standards, or attorneys that would be someone that would know construction documentation, or perhaps the specifications that are provided, say, by a highway district or something like that. So we have that opportunity. So resolution is discoverable, and it comes in the two forms that I said, formal and informal. The D and DRB is what I've already really summarized, and that is, we really don't want, our goal is to end this project, whatever it is, without having any true disputes. We want to tackle it at the issue stage. Maybe it gets into a conflict, but before they really get positional, we try to do our best to get it resolved. Our focus is the project. So that's kind of what the DRB board and the process is. It's very simple. Say for compensation, I'll just mention that each one of these DRBs have a schedule of payment, hourly payment, anywhere probably from $200 an hour up to $500 an hour, plus costs, travel costs and whatnot. As a board member, we typically travel to the project. So if it's international project, then we try to, instead of using Zoom or those kind of devices, we do try to go to the project. Probably if it's international, we do them on a quarterly basis. If they're semi-local, we do them on a monthly basis. If they're local, sometimes if they have weekly meetings, then we go there weekly. And of course, they cover expenses as well. So let's talk about some of the projects that have used DRBs. And these projects are huge. One of the very first DRBs projects that was built in the US were the Eisenhower tunnels just west of Denver. It's I-70, goes underneath the Continental Divide in these tunnels. And the first tunnel that was built, the contractor in those days, and it was like, I think 85 when that tunnel was built, there were a huge number of change orders that the contractor wanted from the owner, which was the Federal Highway District, local highway districts, the state highway district, and some private landowners. So it was very complex on the owner side, but the contractor was a single contractor. He ran into, who knows what you're going to find when you tunnel through a mountain. He found some loose stone that he hadn't accounted for. It created some costs for more shoring. He found some rock that he thought was harder than what the specifications were, and so on and so forth. In 85, his change orders were over $5 million. In today's numbers, that'd probably be $45 million. That's how much construction costs have gone up. So it was a big deal. And they ended up going through the contract at that time, recommended mediation. They couldn't get it resolved. They ended up in court. Well, going to court in a construction project like that puts the project on hold. It's high dollar volume for the contractor to continue working. It's almost impossible for him to continue working unless he's compensated somehow. And the last thing you want on a highway project like that is to have a 6 month or a year delay. And that's what the DRB really tries to address, is to keep their focus is on the project, keep it on time and in budget. So that was the first tunnel for the westbound and lanes. And then they had to do the second tunnel for the other side of the freeway. And they sat down and they said, number one, there's limited number of people that do some of these specialty projects like airports or desalination plants or water projects throughout the world, and very few owners. And if we go to court, we end up not liking each other at the end. And that is what happens in most lawsuits. So let's sit down, let's figure out a way to get this resolved. We can, if issues come up, then we have a sounding board or something. And that's where the DRB Foundation, or the DRB process, was developed. It was about 1987. And the 3 original DRB board members were civil engineers, tunnel experts, and construction attorney. And having that board there available, so for the project, when the boring started, there were changes that needed to be adapted to the project, because again, they ran into some unusual rock layers and some fissures in rocks that appeared to be dangerous and would need some more shoring. Having the DRB on board and working with the owner and the contractor, they were able to write change orders, be friendly about it. The owner felt confident that the number that was being charged by the contractor was a fair number. He ran into some soil that was easier to excavate than what he thought, and the board encouraged a credit. And at the end of that second tunnel, there were absolutely no disputes, no issues, no lawsuits. And that's when the engineering group decided that, hey, we need to develop this process for large construction projects. Let's start the DRB Foundation. And that was started in the state of Washington by a group of civil engineers. That DRBF now has grown to an international group. And for anyone that's interested in training or looking further into some of the projects that the DRB Foundation monitors and offers the education, you can go to drbf.org. And it's a great website, and it talks about a lot of the projects that they have going. It's endorsed by the World Bank, by many, many international groups. And it's just a super group of people. I mean, and they have their meetings in Africa, in Europe, all over the world. And it's a great group of people that really focus on protecting the timing of projects and the costs. One of the other projects that was a great success for DRBs was the Hong Kong airport. And it was started in, I believe, 89. And that airport, I believe there were something like 30 or 40 different countries involved in supplying product for that construction. There were contractors from many different countries that had to work together on this. It's still one of the very largest construction projects that's ever been undertaken. And it took them almost 10 years to build that project. They had many issues come up because they were building on this landfill island, and they had soil problems. They had all sorts of problems, product problems, so on and so forth. Now they had decided that they would choose 9, an uneven number, 9 board members for that DRB, and they met on a monthly basis. After 10 years of construction and hundreds of billions of dollars spent on that airport, there was not one single lawsuit. They were all resolved through the DRB process. Other projects, big desalination plants throughout the world have been built using the DRB. And again, that's the World Bank funding and all of these diverse groups that are trying to get this project put together and are protected with the DRB. So anyway, that's kind of a summary of the DRB process. And I can tell you that most of us, I no longer do mediations. I love the process. I love doing arbitrations, and I've stopped doing that. And for me, DRB is the premier dispute resolution process, and that's all that I focus on. And I'm to the age that I don't, I'm not full-time. I like a break, so I might work a week or 2 weeks a month. And it's a great opportunity to stay mentally stimulated. And you feel really good about going to these. We have never, in the 50 or 60 DRBs that I've been on, I've never once left there with any regrets on the outcomes of our recommendations. And typically the owner and the contractor take the recommendation serious. We're not there to resolve the dispute. We're there to give them guidance with our recommendations. And I don't know of any that I've been on that we've written reviews that haven't taken our recommendation. That's how successful it is. So right now I'm doing highway projects, the large overpasses, freeways and connections and that type of thing. And my background is construction, architecture, environmental planning, and a little bit of law. But the other board members, we have an attorney that's construction law, and that's really all that he's ever done in his career. And then we have a civil engineer. And typically, a good rounded board is what's important to be able to come up with good recommendations. I've had some really interesting ones. And it's not always roads, highways, desalination tunnels, those types of things. But when Natalie and I were teaching and certifying arbitrators, mediators, and dispute review board, the hotel industry became very interested, and we certified a lot of consultants out of the hotel industry. And the hotels, these resort hotels, the large ones, are typically built on donated land by a city or a state or a county, and they're very involved finances. They usually adjoin a public golf course, or there's a real intermix of ownership on these. And sometimes the contractor and the architects struggle to make everyone happy. And I can remember the one that we did. It was a beautiful hotel. It was designed by a top architectural firm out of San Francisco. And the hotel, being a high rise, was a granite clad exterior. And we've all seen them, the shiny stone. They're beautiful, absolutely gorgeous. And the architect in his contract reserved artistic rights so that he could say, hey, if that doesn't look good, I have the right to reject the installation or the product, and an alternative has to be implemented. In this particular project, the granite that he had specified came, of course, out of Italy or Spain, I can't remember now. And it is a natural product, and they do try to take it out of the same quarry, and they number the panels, and these were all quarried, loaded on ships, and sent to the project. So the contractor had to order this basically the day of the signing of the contract. And it was 6 or 8 months, I can't remember exactly, for that shipment to arrive in LA port, and was then transported to the project. So the contractor at that point had the steel structure up. It was all working out great. Project was on schedule, and they were staying within their budget. So the installation of the granite started, and the architect came by after, I don't know, 50 or 60 panels of this beautiful granite was installed. And he said, my gosh, some of the panels are dark, Some of the panels are light, some of them are mid-tone, and my building is starting to look like a checkerboard. And he said, I hate to, but I'm going to reject this load of granite. I don't want a checkerboard looking building. Well, fortunately, they had a dispute review board. They actually called it an issue review board, but a dispute review board, and comprised of myself and others from the industry. And we had asked permission once this was brought up, and it looked like it was going to turn into a conflict, and it was good because the contractor said it's a natural product. I can't guarantee the color. You know, it came from the same quarry, and that's just the way it's going to have to be. And before it became a dispute, we said, hey, could we go out and look at the product? And we did, and we witnessed the dark, the medium tone, and the light tone. And we asked the contractor to get a count on the dark ones, the medium, and segregate them out, the pallets out, and to the light. And what we ran by, just in an informal recommendation to the architect, the owner, the contractor, was, could you consider starting, say, at the bottom, segregate out the granite stones, and perhaps start at the bottom of the building with the dark ones, and then just make a gentle transition with the color of stone to the top. So the light's on the top and the dark's on the bottom, or whichever way you think would look best. But that way you can get rid of the checkerboard. That was in just a verbal recommendation, nothing written. And the light bulb went on with the architect, the owner, the contractor, and they said, hey, that'll work. No change order. And that's what I like about the dispute review boards, is that we're a third party. It's not, there's no money coming out of our pocket. We don't represent any of the parties. We just represent the project. Very successful, saved several $1 million, if not into the double-digit millions. So anyway, that's what it is. That's the process. And I told Natalie that I wanted to talk about the process first and open eyes to perhaps people that have never heard of the Dispute Review Board. But I really would like to have some questions from those that are listening in or attending this webinar. So are there any questions from anyone?
David Armstrong, thank you. What a wonderful presentation, full of information that I think is really news to a lot of people here. Let me ask you first, is there a systematic effort to quantify just how much money is saved and how much time and money is saved by using these dispute review boards?
I'll tell you, Jeff, Caltrans, which they probably do 3,000 to 5,000 projects a year, maintaining the freeway systems and the state highways in the state of California. They have a DRB on every project, whether it's $100,000 or it's $100 million. They have a DRB. The DRB basically assists them if they do become in conflict and they become entrenched. The DRB's recommendation is typically listened to, and that's how it's resolved, because the alternative, going to court, just doesn't make sense, even on a $100,000 project. Typically, they budget as a contingency fee for the DRB. They basically, now the low cost one's $100,000, they have to adjust that up. But on the typical project, which is, say, is from 5 million up to 100 million, they budget about 1% of the project to be spent on the board. It's a contingency fee for the contractor, so they put it in the contract. So let's say it's 100 million. They put in $100,000 into the budget for the contractor, 100,000 in for the owner. So that's $200,000 budget for the DRB. If there's no formal hearings, that we're usually under budget. If we do a lot of, not hearings, but reviews, if we do a lot of reviews, we exceed it, and both parties are responsible to share in that cost. So that's about where that is. To me, there's no limit. I mean, if it's a $10,000 project, it's hardly worth bringing in the DRB. But.
Fascinating. So to do this kind of work, you pretty much have to have decades of experience in the construction industry, one way or the other?
Well, yeah, but it doesn't have to be construction. These are used like the water systems in Africa or these desalination. It could be a cultural background. It could just be someone from that country that represents, that particular culture, or it can be a variety. But I always like the boards that I have attorneys. I like having someone there, whether it's a construction expertise or it's just a seasoned individual that can really look at codes, laws, and guide us where the courts would most likely go if it went to court.
And are these kinds of dispute review boards applicable in other sorts of industries as well, where there's high stakes and long-term relationships in play? Thinking of all kinds of transportation industries. There was a comment in the chat about the pharmaceutical industry. There are many other industries that might come to mind.
Yeah, oil production. That's such a sensitive subject right now. The oil industry, any of those. So yeah, it's the DRBs now are being implemented in a multitude of complex projects. That just seems to be suitable. Get those neutrals in there. We almost become recipient witnesses. If we're there on a monthly basis or we're there in their weekly meetings, we see where perhaps a mistake was made, or we can even bring up a question during these meetings and say, it seems like to me, we're hearing an issue. Is it something we should talk about? No, it's not an issue. We'll get it resolved. But we're there. We listen to that. I sit on 6 DRBs right now, and I'm the chair of 4 of them. And I get meeting notes. I get copies of all their emails between the parties. I get schedules, I get costs, budgets, all of that. And so then I share them with the other board members. And so we're up to date. It's like we're there. We're just a fly on the wall, and we know the 2 parties and some of their strengths and some of their weaknesses, and we're good listeners. And that's what it takes, is a good listener more than anything.
Well, let's listen to Valerie Eddy, because she has a question. And Valerie, why don't you unmute yourself, please, and pose the question on your mind.
Good morning. Thank you, David and Natalie. Natalie and I go back a long time. Great to be a part of this. My background is in the construction industry. I'm in Southern California. I have over 35 years, mostly in heavy equipment. So do you get into these dispute review boards? Do each individual company set it up, or do you go through the foundation? How do you get started in getting into those review boards?
It's a good question. If you are in California, you simply log on to Caltrans website and say that you would like to consider being a board member on some of their disputes or on some of their projects, I'm sorry. And they will send you a form, and you fill it out and you submit with your background. And then they have a whole list, and Caltrans has a huge list, maybe 2,000 neutrals that are available that are well qualified. And then if your majority of your career has been in excavation, if it's something that involves, well, like here in Idaho, we're trying to improve the northbound highways because of the mountains and the canyons. There's one project here that's a 3-year project, and it's a lot of dynamite rock removal. It's a 3-year project. I think it's around 600,000 tons that they've moved so far in the 2.5 years. So the two parties, the contractor and the highway district, then would go through the resume of the available board members. And if they see someone that's heavy into excavation, then they would probably put you in one of their selections and then pass it amongst each other. And we have excavators. I've served on boards with excavators, bridge builders, highway contractors, architectural contractors. So yeah, that's how you apply. And Caltrans is probably a good one for you. Nevada also has DRBs. Washington State has a lot of DRBs on their large projects. Idaho, Colorado. There's a multitude of states that do that. So just a little bit of research. But the first thing they're going to ask is, are you certified by the DRB Foundation? So one of the first moves you do is contact the drbf.org. They'll have a list of classes that are available to you, and you sign on to those. And they have them in California and Washington, all over the place. Or you go to Africa or Europe, make a trip out of it, have some fun, and do your certification and then your resume. And that's how you get work.
Yeah, I was going to ask about the certification because as a mediator, I know that your certification can be from state to state, correct?
Yes.
Yeah.
And typically 40 hours of training. Now, the DRBF, they have the basic training, and then they have major project training. And then they have training for being the chairman of one of these boards. So I think there's 3 classes that they offer, and they're 8-hour typical classes. So you can fly into Florida, or if it's there in LA or wherever, you go and it's an 8-hour thing. They also, during COVID, were doing them by Zoom. So you just participate for your 8 hours and you get your certification.
Yeah, I've been a mediator for over 10 years, doing a lot of wildfire cases right now between homeowners and insurance companies, which puts both my automotive background and my construction background into place. But unfortunately, with the contract with the Department of Insurance, it's not as lucrative as you might think. They might give you two cases a year. You're on a rotation of several mediators. So but I enjoy the process of mediation so much, just like you. Did you find that like Caltrans is great? Do you like individual companies like Lasardi and things like that? Do they do them, or have review boards, or do you think that it's just, or some of the bigger contractors, or do you think it's mostly Caltrans that would have those kind of disputes?
Well, I really don't know. I know that engineering firms that know about the DRB process are writing in 3-party agreements into the contracts, or their attorneys, construction attorneys, are writing in the 3-party agreement. And that's the most important part. I think if you go to drbf.org, you can download a book. I think there's a small fee for buying the book. And in that book, as copies of a 3-party agreement. If someone asks you, because of your experience, would you help us with this project? You could download that and discuss it and maybe put it together. And it doesn't have to be a 3-panel. I have a good friend up in Seattle that we're doing these highway projects, but his background was architecture, similar to mine. And he approached a school board. He served on a couple of DRBs for a school board there, a large school board. And the school board, he approached him and said, instead of doing a three-party, a three board, would you consider a single person board? I will just, when you build a new school, I don't represent you. I don't represent the contractor. I'll look at the plans and whatnot. If an issue comes up, then I'm a neutral and I will try to help you get along so that there's no conflicts. And he has now done 70 schools as a single member DRB. So you could promote yourself that way also.
Great. Well, thank you for all the advice. I really appreciate it. And thank you for this webinar today.
Yes, and thank you for your questions, Valerie. There's a question in the chat. Dave, is there ever conflict among three people? Is there ever a dissenting recommendation, or what happens if there is that kind of disagreement among people?
That's a really good question. You know, it's written in the three-party agreement of what happens if there's a conflict or a disagreement amongst the board members. Two of the board members can rule, say, in one direction, and then you can have it dissenting. All those recommendations are given to the two parties, and then they can figure out which one or whatever they like. But I've never served on a board that the board members weren't together and saying, look, we're not going to be divisive in our recommendations. If we can't resolve it amongst ourselves, then we haven't done a good job reviewing the data and the problem. So I've never been on one that we've had a dissenting vote, but it is possible. And the three-party agreement addresses what happens if there is.
Okay, our friend Roger Moss up in Northern California, I believe, and then Stuart Baker after that, please.
Okay.
Thank you, Jeff, and hello, David, and thank you so much for being here today. You have been a legend in my mind for a long time through my association with Natalie, and it's just wonderful to meet you virtually. So thank you. I was really struck by the observation you made early on in your remarks. I think you were coming out of the Pepperdine experience, and you saw the limitations of the word and perhaps what people think of the word mediation. I also, that connects to the appropriate dispute resolution phrase, which is much more common internationally than in the United States. Mm-hmm. And another mentor of mine, Colin Rule, everybody probably in this call knows him, made similar comments to me years ago that really influenced how I tried to build my private practice and now a program that I manage. And I wonder if you could just talk about that a little more. It's my view, and this was kind of combining what you said with what Colin said to me, is we don't like to talk about this as a group, but most people who participate in mediation don't, as it is traditionally performed, I should say, don't necessarily come out of it being in love with the idea of mediating. And there's a tension between our passion for being peacemakers and calling ourselves mediation with trying to draw people or organizations or communities into a process. And so to the extent the word itself maybe should be de-emphasized is something that interests me. And I would love to hear you talk about that.
Well, the last mediation I did was about 3 years ago. And I flew in, I did the mediation. It was a court mandated mediation. And those are always tough because to mandate someone into mediation, it's a real struggle for us mediators. And it was a water intrusion problem in a dentist's office. And the dentist's office was located in a shopping center. And adjacent to him was a Chinese restaurant. Chinese restaurant went bankrupt, foreclosed on. The space was empty. And the proprietor of the restaurant had a Coke dispensing machine in there that he left behind. And I can use names because it was a lawsuit. But this was a dispute between a dentist and the Coca-Cola company. who he felt was responsible for the water intrusion because apparently a rat had eaten a hole in the connecting water hose to the dispenser. And that's what flooded his space. And you know, after doing a lot of mediations, I just thought to myself, here's a contingency fee attorney suing a large corporation for something that a rat did, only because he can't find the rat to sue, and he has no legal premise to sue the rat, even if he did find him. And so you just pick the person with the biggest pocketbook, and that was the Coca-Cola company. And the attorneys on both sides were entrenched and in positions that were impossible. Being offered $2,500 to settle. No, I won't settle for less than, $500, whatever the numbers were. And I didn't get that one resolved. I tried. I did everything that Pepperdine University taught me about mediation. I pulled the strings from my heart for all the experiences I had. When I got on the plane to fly home after the mediation, I just thought, I worked doing these DRBs, and that's where I feel most comfortable. I know by sitting there and trying to address the issue and the project, focus on the project, not the people, I'm accomplishing something every time I go to one of those meetings. And that's why I dropped the mediation, I dropped the arbitration business, and that's all I do with DRBs at this point.
If I may, that's a beautiful story. It connects for me very personally because it was a 30-year career in the shopping center industry that led other people to say, you ought to be a mediator, because I would show up when people couldn't sort things out and prevent them from doing that court case. But I never realized or thought of myself as mediating. But it was only when I let go of trying to go to work as a mediator and remembered I had that expertise in that environment that things started to work. And for me, the touchstone for me is this idea of I'm a professional neutral and a negotiator and a problem solver.
Yes.
In a particular context, that if we can just get back to talking about the facts, all will be well, and we can heal relationships too. So Thank you for sharing that. That was beautiful.
I can't remember who told me this story. It may have actually been Jeff. And Jeff, you can validate it or not, but there's a story about a postal worker is delivering mail, and it comes up to this home, and there's like 5 or 6 steps up to the porch that he has to go up and put the mail through the door slot. And there happens to be a young man and a dog sitting on about halfway up the stairway. And the postal worker talked to the boy and said, does your dog bite? I'm fearful of dog bites. And the young man said, no, my dog doesn't bite. So the postal worker took 2 steps up the stairway. The dog lunged at him and bit his leg. Postal worker stepped back and he said, young man, I ask you, does your dog bite? And the young man said, my dog doesn't bite, but I don't know who belongs to this dog. And so experience that you're talking about, some gray hair, trying to get people to work together and resolve things, we become really good listeners. And the postal worker didn't make a mistake, but we as DRB members have to say, okay, if your dog doesn't bite, does that happen to be your dog or not? I mean, that's where our gray hairs come from. And so that's our role when we work on these projects. Ask the questions.
That's a great story, David. I don't think I'm the one who, it sounds more like a Peter Robinson story, frankly. But I'm happy to learn it now. Stuart Baker, you have a question, please.
Yes, thank you. And thank you, David. This is great. So my question is basically trying to adapt this into the light construction industry. I've got many years experience in it, also many years as a part-time mediator and occasional consultant. And I've tried to kind of promote myself in my own version of this. And I haven't gotten anywhere, so to speak. And I actually talked with a woman, I think she runs the office of the Dispute Resolution Board Foundation. She was very, very helpful about taking training, getting my name on the list, joining. I just wonder if you had any quick thoughts about it.
Well, I'll tell you what, if you have a chance to do any consulting, you know, in light construction, we're bound by the AIA documents, and the American Institute of Architects recognizes the DRB process. But talk to those architects, talk to the engineers that issue the contract that people sign. And right now, most of those documents say mediate and then arbitrate. But they can line those out and put in a dispute review board and put in a contingency fee to cover the cost. Because even in light construction, some of them are very complex and very difficult. I worked on a home in Malibu as a personal advisor to the owner, not the contractor, on the beach where a house should not have been built. And I was consulting with her for 19 and a half years on that house. She spent $43 million on the home. It's a beautiful home, but that's considered light construction. And I was a single neutral. I did work for her, but all of our meetings, I focused on the project. And like one of the other gentlemen said, you know, you focus on the tile issue or the crack in the concrete issue and not the contractor or the owner, you know, resolve the crack in the concrete. So if you have a chance, talk to architects, educate them. Natalie and I, when we were doing the training, we did have the blessings of the AIA, and we educated, I don't know how many, Natalie can tell you, at least 800 or 900 architects took the course. And I believe, hopefully some of them are changing their contracts. So maybe that'll help you.
Thank you.
All right, we have just a minute or two left. Any last minute questions? Yes, Janice Sparrow, please.
Hi, thank you. I found your information super helpful. I've been working in the dispute prevention space with CPR and a few other organizations.
Yeah.
But I would like to get more involved in the boards. What is the basic training that you recommend for someone who's already, you know, done dispute prevention and has served as a standing neutral in a contract on their own, but has never been on a board? What do you recommend?
Definitely take your training from the Dispute Review Board Foundation and contact them and tell them you want their training. And then that's your first step you need to take.
Okay, we are about out of time. I want to remind first of all, thank you, David. This was a really illuminating presentation. Natalie, thank you for your really hard work to recruit such an outstanding speaker for us and your stewardship of the Will Work for Food project over the last 2.5 years. Jean Lawler, it's always great working with you, and Sarah Agramiri as well. We remind everyone that if you're in a position to support the Idaho Food Bank, that would be wonderful. It's www.idahofoodbank.org. That's www.idahofoodbank.org. And Natalie, I'm going to turn it back over to you for any last comments and acknowledgements and to sign us off.
Thanks, Jeff. And Pop, thanks so much for doing this for us. I'm so happy to introduce you to my Will Work for Food community. And now all of you know that it is absolutely positively his fault that I am a second-generation resolutionist. My daughter is a third-generation resolutionist, but it all started with Dave and his passion for really, truly wanting to help people avoid disputes, avoid conflicts, keep things moving forward, keep things positive. And so I owe everything that I do, everything that I touch is absolutely because of my parents. I
Oh, wow.
won the parental lottery.
Great. Good to hear. Anything I can do to help.
And you don't look like him at all.
I realize that, Janice. It's an absolute mystery who the father was, right?
All right,
All
friends. Thank you so much. Wonderful presentation. We'll see you next Thursday. And with that, we are complete.
All right. Thank you.